No, I didn't take my eyes off of him.
You never looked at the gun?
For a second.
You only looked at the gun for a second. Okay. But you told the police that one reason you thought it was a toy was because you didn't see cartridges being ejected from the gun.
That's correct.
And in fact, you were thinking of buying a gun, weren't you? Prior to the shooting.
I don't recall that.
You don't recall telling the officers that you wanted to clear your record so that you could buy a gun?
I may have said that.
Well, was that or was that not true? Were you not intending to clear your record and buy a gun?
No, I object. This is character evidence, and character evidence is not relevant in a criminal case unless it has to do with truthfulness or untruthfulness. That's the only time character is relevant in a criminal case. I don't know when he says clear your record, this is asking character evidence of this witness, and I call the court's attention
aside from the fact that let me know when you're done, Mr. Economist.
May be a while. You're on a 404A2. Evidence of a character trait. And the character of witnesses. 404. And also with respect to impeaching a witness, I don't see where character has anything to do with it, and that's what he's trying to do. What is the relevance of the character of this witness to the guilt or innocence of the accused in the case? If you're going to talk about character and to impeach the character of the witness, you have to do it with instances that relate to truthfulness or untruthfulness. I don't understand where this is going.
Mr. Goff, your turn.
I just want to make sure Your Honor, of course, the first thing I'd point out is Mr. Economo did not timely object. I asked essentially very close to the very same question, eliciting the same information, to which the state interposed no objection. To that extent, their objection is untimely. Beyond that, Your Honor, this isn't a matter of going into Ms. West's character here. This is a matter of using her own words to refresh her memory as to what she said. She said that she wanted to buy a gun, and she not only said she wanted to buy a gun, but she indicated her determination to do so because she indicated there was something important she was going to have to do to make that happen, Your Honor. It's not being tendered for the truth of the matter asserted. Whether she has a record or not really is not the issue here. The issue is that she was talking about buying a gun in the same time frame that her child has been killed in a shooting, Your Honor.
I heard the word record, to clear a record. What record are we talking about here?
I'd ask Mr. Economo the same question.
You know, the record.
All right, ladies and gentlemen, if you would please rise and go back to the jury room.
All rise to the jury.
Absolutely. Yeah.
These are the police.
All right, so there'll be record reflects the jury's been removed. All right, first is the rule as to if a witness on the stand testifies under oath to a collateral fact that the cross-examiner believes in good faith is false, the cross-examiner may confront the witness with the contradiction but must accept the witness's answer. Is that what we have here, Mr. Goff? I mean, that she made a statement about something that's collateral to this case, or?
Well, Your Honor, let me begin by pointing out that we specifically asked for Ms. West's criminal history outside the state of Georgia, which we cannot obtain. As your court will well remember, it was the state that interposed any objection to us learning what a record is. We don't know whether she has a felony record or a criminal record. We do know she has a misdemeanor. I don't assume that's not what she's talking about. But we don't know. But, Your Honor, point number one is the objection's untimely to the extent that they want to strike an question that's already been asked and an answer that's already been given. It's not timely. If they don't want us to ask the question a second time, it's a slightly different way, but that's fine. But Mr. Economo doesn't get to come back after the question's already been asked and already answered and we've moved on to the next question. He doesn't get to interpose his objection at that time. It's simply untimely, Your Honor. But beyond that, it's not being interposed to address her character. She's given an answer about her interest in obtaining a weapon, and she's given a very specific trigger as to why, no pun intended with the trigger, as to why why that conversation was taking place, and it was important enough to her that she was going to have to go through that hurdle to be able to obtain a weapon.
This is a statement that she apparently made to the police.
I believe it's in the statement she made to the police. That's what my notes say.
Okay. And so you're going through, we've had, obviously, everything that she said to the police, or all questions that police ask, or not just because the police ask a question doesn't make it relevant for purposes of this trial.
No,
And so, I mean, the court's not making a finding that every single thing that is asked by the police department necessarily comes in, because they're like a deposition. They're in search of all different types of things.
Your Honor, I think we can agree that simply because the question was asked.
I mean, and to ask
make
a witness about her record, and I mean, I think the court is straining to find any relevancy as to pointing out that she wanted to clear her record.
Well, Your Honor, relevancy would be a 403. It wasn't raised at all the first time, but to the extent it's being raised now, we can address that. Mr. Economo hasn't made that argument. I think that what the court asked me about specifically, and the objection that Mr. Economo raised, was a 402 objection. And I think your court, as Your Honor pointed out, if the witness acknowledges the fact, then it's done. And the witness has already once, and we were asking a second time. So I think based on your court's own understanding of the rules, which at this point there's no reason to quibble with, both questions and both the first answer already given and not objected to and the second answer would be permissible. But, Your Honor, if the court wants me to withdraw the question, I will.
The court's going to sustain the objection after the second to this question. All right, let's bring the jury back in.